Welcome to Elise Explains IP, the show where I make intellectual property simple, practical, and genuinely useful for your business. I'm Elise Steegstra, an IP lawyer with over 15 years' experience helping creators and founders protect and commercialise their ideas. Each episode, I break down a key part of IP, trademarks, designs, copyright, brand strategy, and the real issues that arise when your ideas hit the market. Quick disclaimer, this is general information, not legal advice. For guidance on your specific situation, make sure you get personalised advice. So let's get into it. Ever wondered what makes successful businesses thrive in today's marketplace? My name's Elise, and this is Elise Explains IP. I'm an intellectual property lawyer, and I've spent more than 15 years working with clients on trademarks, designs, and copyright, helping them protect, manage, and commercialise their intangible assets. Today's episode is an overview of the foundations of IP in Australia. By the end, you'll understand the major types of IP, what they protect, where the risks are, and how to structure your business to get the most value out of your IP. Today, we'll explore at a high level trademarks, design registrations, copyright, confidential information, IP ownership, and business structuring risks, investment considerations, and commercialisation pathways. This episode won't cover very much about patents. They're highly technical and best handled by a registered patent attorney. So, let's jump into it. What is a trademark? A trademark is any sign used to distinguish your goods and services from somebody else's. It's used to identify the source of the goods or services. It can be a word, a logo, shape, sound, colour, even scent, or any combination of these. Yes, scent. For a trademark to be registered, it must be distinctive. Melbourne Cleaning Company describes the service and location. It's not distinctive, and it can't be monopolised through trademark registration. Made-up words like Google, or words used out of context like Nike, Uber, Amazon, Apple, for computers. These are likely to be more inherently distinctive. However, I can't register Google, even for my orchard, as a trademark has to be not identical or not substantially similar to an existing registration, particularly not one with a very large reputation. So, why does registration matter? Trademark registration gives you a legal monopoly. A business name, a company name, or a domain name registration does not. ASIC, Australia's company registration body, and .order, the controller for .com.au domains, only prevent identical names from being registered, not similar ones. Therefore, you could register a name and still be in a world of hurt. Only a trademark protects your brand and lets you enforce it. Before choosing a name, you should search the trademark register, check for similar marks, review your mark for potentially misleading and deceptive conduct risks, and avoid passing off on any particular existing brands. When you own a trademark, you can stop others from using an identical or a confusingly similar mark for the same or similar goods and services. What's a design? Designs protect the visual features of a product, being the shape, configuration, pattern, or ornamentation. It doesn't protect the function of something or how something works. That's what patents do. Only their visual appearance. Common designs include furniture, packaging, tools, fashion, and consumer products. Some businesses have attempted to register user interfaces. This area of law is evolving and not always straightforward. Designs must be new and distinctive when considering the existing designs out there, and it needs to be supported by drawings or images. In Australia, they have to be certified before they can be enforced. Registration gives protection for up to 10 years in Australia. Now, let's talk about copyright. Copyright protects the expression of an idea, not the idea itself. It covers things like text, music, artwork, software code, graphics, databases, course materials, and manuals. You don't need to apply for copyright in Australia. It arises automatically upon creation of a work in tangible form. However, issues can arise around creation. This is where many businesses get caught out. If you outsource your software development, branding, design, marketing, web development, or anything like that, you may not automatically own the copyright. You'll need to check your contract, and you may need written assignments. Copyright infringement arises when you take a substantial portion of somebody else's work. Doesn't have to be a huge part of it, even using a small part of someone's work, can infringe if the section is significant enough to be recognisable. In Australia, we don't have a fair use exception like in the US. Rather, we have very specific fair dealing exceptions, which exist for the purposes of research or study, criticism or review, parody or satire, news reporting, and for a legal practitioner, registered patent attorney, or registered trademark attorney to give professional advice. Hey, that's me. Confidential information isn't a registered IP right, but it's incredibly valuable. It includes things like recipes and formulas, like the Coca-Cola recipe, business methods, customer lists, pricing models, strategy, and other trade secrets. Protection of confidential information requires non-disclosure agreements, limiting access and controls, clear labelling, a big confidential stamp, and other practical systems to keep the information secure. If you don't treat it as confidential, the law won't help to protect it. And who owns the IP really matters. It can affect capital raising, investment, tax, saleability, asset protection, and risk isolation. Many businesses hold IP in a separate entity and then license it to a trading entity. This can help ring-fence risk, it can simplify investment, it can make IP easier to sell, and ensure that the clear ownership of the registered rights. Investors want to see clean chains of title. They want the IP to be owned by the entity they're investing in, not in any particular founder. However, if you register your IP in the wrong entity, or you don't properly license use between entities, you can risk invalidating your registrations. So, get it right. And that's a high-level overview of IP in Australia. Thanks for joining me today. I hope this gave you a clear and practical overview of the main forms of IP in Australia and how they work together. Understanding what you have, how it's protected, and how it can be commercialised is one of the most important things and powerful steps you can take as a business owner. I'm Elise Dijkstra. Thanks for spending this time with me. And if you're ready to protect and commercialise your valuable assets, please reach out to me via my website at elisestijkstra.com to schedule a free strategy call. Thanks for spending time with me on Elise Explains IP. If you picked up something useful, hit follow, subscribe, leave us a review, or send it to that friend that keeps borrowing other people's ideas. And remember, this is general information, not legal advice. If you do want help with your IP, you can book a strategy call with me anytime. The link's in the description. Until next time, own your own ideas.